Yes. Thank you, my Lord. My Lord, my colleagues have indicated that my client, my Lord, the first respondent, has aspirations to be the 6th president of this country. My Lord, for the record, I confirm yes. Honorable Moses Masika Wetang'ula has those aspirations, my Lord. And as a lawyer, my Lord, I'll be the most happiest person to see a lawyer leading this country as the president. My Lord, that speaks to the petition that is before you, that is seeking to curtail the aspirations, my Lord, of a citizen of this country. This petition, my Lord, is therefore more political than raising a constitutional question for determination by a high court sitting as a constitutional court. My Lord, every person or individual has ambitions, and there is absolutely no violation if the Speaker of the National Assembly has such ambitions, my Lord. My Lord, there was an issue about the affidavit that was sworn by the Clerk of the National Assembly, and I heard my colleague, my Lord, state that the Speaker has been sued in his personal capacity. My Lord, parties are bound by their pleadings. And I refer you, my Lord, to paragraph 31 of the petition, which states, my Lord, that the first respondent is the Speaker of the National Assembly, established in Article 106 of the Constitution. My Lord, the person before you is the Speaker of the National Assembly, not Wetang'ula in his personal capacity. Nowhere, my Lord, has in the petition been stated that he has been sued in his personal capacity. To that extent, therefore, my Lord, the Speaker of the National Assembly, my Lord, being an office established under the Constitution, in a House of Parliament, the clerk of that House, my Lord, has power, mandate, and authority to depone on issues that have been raised in this petition. My Lord, paragraph 2 of the replying affidavit is clear that the deponent has been duly authorized by the Speaker himself, my Lord, to swear and respond to the issues before you. That, my Lord, then brings me to the substantive responses, my Lord, and which are to be found in the replying affidavit sworn by Samuel Njoroge, my Lord, on the 15th of July this year. We also, my Lord, rely on the skeleton submissions dated 16th of July, my Lord, as well as our case digest, my Lord, and list of authorities dated the same date. Briefly, my Lord, I'll be addressing you on 3 limbs, which are whether, my Lord, there is a prima facie case. Secondly, whether if the orders are not to be granted, the petition will be rendered nugatory. And thirdly, my Lord, on the question of public interest and prejudice. My Lord, on the first issue, on whether there is a prima facie case before you, our position, my Lord, is that there is none. And I say so, my Lord, for the following reasons. 1, jurisdictional questions, my Lord. And, my Lord, we all know that jurisdiction is everything. My Lord, it is our humble submission that this court do not have jurisdiction to preside and entertain this matter for the following, my Lord, three reasons. One, under the doctrine of exhaustion, that, my lord, there exists alternative dispute resolution mechanisms that are mandatory and that ought to have been invoked by the petitioner before approaching this court. That, my lord, I'll refer you to paragraphs 49 to 58 of our replying affidavit. And you shall note, my lord, that the petitioner's complaint is about the conduct of the first respondent as a state officer. Paragraphs, my lord, 49 to 58 of the replying affidavit. The petitioner's complaint, my lord, is against the first respondent's conduct as a state officer. Three clear, my lord, statutory avenues are available in prosecuting, my lord, and determining such a conduct. And the first one, my lord, is under the Powers and Privileges Committee of Parliament. My lord, that statutory mechanism is to be pursued under Section 42, my lord, of the Leadership and Integrity Act, as well as the Parliamentary Powers and Privileges Act. No attempt has been made or shown that such a complaint were lodged to that committee. The second avenue, my lord, is that the petitioner would have filed a substantive motion under, my lord, the National Assembly Standing Order 87-1, complaining against the conduct of the first respondent. The third avenue, my lord, is that the petitioner had an opportunity to file a complaint to the EACC, my lord, who is the fourth respondent hearing, under Article 252 of the Constitution, as read together with Section 11 of the EACC Act, my lord. My lord, you shall note that under Prayer C of the petition, the petitioner itself seeks this court, my lord, to compel or to direct EACC to conduct an investigation. My lord, the question is, which action precedes the other? Is it complaining to the EACC or coming to this court for the court to direct EACC to investigate the complaint? Our humble submission, my lord, is that the first port of call ought to have been the EACC and not this court. And, my lord, that is not an idle submission. We will refer you, my lord, to our case digest. The decision, my lord, of the decision, my lord, that's our decision number 6. No, our decision number 3, my lord. The decision of Aloch Polo by the Court of Appeal, my lord, which stated that if there exists an alternative mechanism, my lord, then the court ought to down its stool. Similarly, my lord, authority number 10 in our case digest, my lord, That is the authority that was given by your brother just the other day, the authority of Rastafari Society. Rastafarians, my lord. Judge Mamuye was expressed, my lord, that you must first exhaust, otherwise the court has no jurisdiction. On that ground alone, my lord, even without much ado, you ought to dismiss the application that is before you. But we have other two grounds, my lord, which is first, that this court also lacks jurisdiction under the doctrine of res judicata, my lord. My lord, the petition before you does not raise any novel or new issues which has not, my lord, been litigated over before this court. And we have extensively, my lord, under paragraphs 31 to 39 of the replying affidavit, my lord, referred you to the particular cases, my lord, that have already dealt with these issues and determined them. My lord, you shall note that those cases that we've referred you to are three-bench decisions of this court. And my lord, I'm more interested in the case of Gachagua, which is at paragraph, my lord, which is our authority number 4, where the court, my lord, was clear that there is a difference, my lord, between predetermination, my lord, and predisposition. That the mere fact, my lord, that a state officer, elected state officer, my lord, has an inclination, my lord, to a particular political affiliation by and itself, my lord, does not constitute bias. That is, my lord, the position before you this morning. In your humble time, my lord, we'll ask you that you go through those decisions, and that if those issues, my lord, you'll find that similar issues have been determined, then, my lord, enough judicial ink has been spent, my lord, on this issue of whether the Speaker of the National Assembly, my lord, can hold a political office or affiliation or engage in political activities. You ought not, my lord, waste more ink on that question, other than, my lord, down your tools. My lord, the third point is on sub judice, my lord, that there are, my lord, as we are before you this morning, pending matters that are raising similar issues as those that are before you. And, my lord, we have extensively referred to at paragraphs 40 to 48 of our replying affidavit. And, my lord, I wish to refer you to only one aspect, that, my lord, there are 6 appeals that are pending before the Court of Appeal, whose determination, my lord, will dispose of in entirety the question that is before you this morning. And in particular, my lord, I'll refer you to appeal number E105 of 2025, my lord, that was filed by the Speaker himself. E105, my lord, of 2025, that was filed by the Speaker himself. Similar question, my lord. That appeal, my lord, is pending before the Court of Appeal. My lord, there is a principle that I will mention before you, my lord, of deference. That, my lord, the best way of handling this matter is that this court, my lord, does not engage on a matter that is pending determination before a higher court. And my lord, even before I conclude that part, my lord, we have annexed the copy of the memorandum of appeal at, my lord, page 257 to 263, my lord, of the replying affidavit, which the court will wish to refer to. My lord, what if this court were to make a decision that will be in conflict with the decision that will be made by the Court of Appeal? What are the embarrassments, my lord, to the judicial authority of this court? Would we be inviting this court to engage? And my lord, the second case, which is E476 of 2025, is due for highlighting submissions on the 28th of September this year, before this same division, my lord. The possibility, my lord, of conflicting decisions over this matter, my lord, is so high. And the best way, my lord, is for this court to await the determination of those other courts, as opposed, my lord, of making another determination and another determination and another determination, my lord. My lord, if you are not convinced, my lord, that you do not have jurisdiction over this matter, I'll then submit, my lord, that even on evidence, this petition, my lord, cannot succeed. And I say so, my lord, because first, the evidence that has been, my lord, relied on by our learned colleagues is inadmissible. And we have, my lord, in extenso, referred you, my lord, to those issues at paragraphs 10 to 13 of the replying affidavit, where we are seeking, my lord, that you expunge all those depositions, my lord, and the annexures of the media reports, screenshots, and such kind of things, my lord, that have been relied on as evidence to support the conservatory orders that are before you. The other point, my lord, quickly, is that the petition, my lord, has been anchored on misinterpretation, my lord, of the Constitution and statutes. And there's one particular point that I'd wish to highlight, is that the entire question, my lord, of restriction of state officers participating in political activities, my lord, is limited to only one class of state officers. And, my lord, these are appointed state officers. My lord, extensively we have discussed that issue at paragraphs 66, my lord, to 86 of our replying affidavit. And in brief, my lord, the speaker, the first respondent before you, is not an appointed officer. He is an elected state officer and a member of parliament. And just for avoidance of doubt, my lord, Article 97D of the Constitution places the speaker as a member of the National Assembly. And as an elected officer, my lord, he is exempted from the restriction not to participate in politics by virtue, my lord, of Article 77(2), as read, my lord, together with Section 12(2) of the Political Parties Act. My lord, I heard my learned colleagues say it does not matter whether you are elected or not. Yet, my lord, it's not us who are saying that. It is the Constitution itself which exempted elected state officer in the nature of the Speaker from not participating in politics. My lord, if that were to be the case, why is this petition not filed against the members of Parliament? All of them, if it didn't matter. Why is this petition, my lord, not filed against the president of this country? He's a state officer. Why is he not before you? Why is this petition, my lord, not filed against the elected members of county assembly and the speakers of county assemblies? Aren't they not, my lord, state officers? My lord, you are being invited to create a confusion to the Constitution, which Constitution itself is clear as to who the restriction applies. The last point, my lord, on that is that my learned colleague also, or the petitioner, has misapplied, my lord, statutory provisions. And I will refer you, my lord, to our paragraphs 87 to 97 of our replying affidavit, where you shall note, my lord, for instance, that the petitioner, my lord, has invoked a repealed law, the Public Officers Ethics Act, my lord. How can we sit, my lord, we are arguing a petition that is anchored on a repealed law? How, my lord, can you grant an order of a petition filed against, relying on a repealed law? My lord, that cannot happen in this Constitution division. Based on that, my lord, looked wholesomely, is our position, my lord, that there can be no prima facie case that have been raised, my lord, that will require that you grant a conservatory order. My lord, the other limp that I would wish, my lord, to refer you to is the nugatory aspect. My lord, you shall note that nothing of substance have been said in this court, my lord, even this morning, that will be rendered nugatory if it were that the conservatory orders were not to be issued pending the hearing and determination of the petition. My lord, I've kept on asking myself this question. What is there to be preserved by a conservatory order? What is in this petition to be conserved? Are we conserving the office of the Speaker? He's been the Speaker since, my lord, the year 2022. Nothing has changed. He's the same person, doing the same things, my lord. What is that is very urgent that to be conserved this July 2026? My lord, this is pure politics. That the purpose of the conservatory order, my lord, is to gag Honorable Wetang'ula from pursuing his ambitions, my lord. Is to gag Honorable Wetang'ula, my lord, from engaging the public. Is to gag Honorable Wetang'ula, my lord, from speaking his mind and opinion. My lord, the duty of this court is not, my lord, to gag citizens of this country. My lord, under Article 38 of the Constitution, my lord, the Speaker of the National Assembly has a right, as a citizen of this country, to engage in political matters and pursue a political cause of his own choice, as well as support a political party or coalition of his own choice. This court, my lord, cannot be asked to prefect, monitor, my lord, or guide a citizen of this country what to say and how to say it. It has never been, my lord, the purpose and duty of this court. But more importantly, my lord, what will the conservatory order serve if it were to be granted at this stage? What is it that the petitioner would lose, my lord, if it were to await the determination of the main petition? There is absolutely none, my lord. The declarations that have been sought, my lord, cannot be overtaken by events if you are not to grant a conservatory order. And that, my lord, takes me to the next point, which is whether the public interest, my lord, will be served by granting the orders herein, or whether, my lord, there will be any prejudice that will be suffered.